All right, ladies and gentlemen, at this time I will review what you can get on top of this final. You have been selected as jurors and have taken an oath to well and truly try this case. Keep an open mind. Do not make a decision about the outcome of this case until you have heard all the evidence, the arguments of counsel, and my final instructions about the law you will apply to the evidence you've heard. Your decision must be based only on the evidence presented during this trial and my instructions on the law. Therefore, from now until the trial ends, you must not conduct research on your own or as a group. Use dictionaries, the internet, or any other resource to gather any information about the issue. Investigate the case, conduct any experience or attempt to gain any specialized knowledge about the case, or receive assistance in deciding the case from any outside source. You must also not use laptops or cell phones in the courtroom or in the jury room while discussing the case. Consume any alcohol or drugs that could affect your ability to hear and understand the evidence. Read, watch, or listen to anything about this trial from any source whatsoever, including newspapers, radio, television, or internet. Listen to discussions among yourself and receive information. Listen to discussions among or receive it from other people about the trial. Or visit or view the scene of any event involved in this case. If you happen to pass by the scene, do not stop to investigate. Finally, you must not talk to any of the parties or lawyers, any of the witnesses or members of the meeting. If anyone tries to talk to you about the case, you must tell the bailiff or me immediately. You may discuss the evidence with your fellow jurors during the trial, but only in the jury room, only when all of you are present. Even though you are permitted to have these discussions, you must not make a decision about the outcome of the case until your final deliberations begin. Until you reach a verdict, do not communicate about this case to your division or your deliberations with anyone else. In this age of instant electronic communication and research, I want to emphasize, in addition to not talking face-to-face with anyone else about the case, you must not communicate with anyone or post information about the case or what you are doing in the case by any means, including telephone, text message, email, internet, chat rooms, blogs, or social websites, such as Facebook, MySpace, and Twitter. You must also not Google or otherwise search for any information about the case or the law that applies to the case and the people involved in the case, including the parties, witnesses, lawyers, and judges. During the trial, you may tell people who need to know about that you are a juror, and that you may give them information about when you will be required to be in court. You must not talk with them or others about anything else related to the case. After your service and the jury is decided, concluded, you are free to talk with anyone about the case and do whatever research you wish. I want you to understand why these rules are important. Our law does not permit jurors to talk about the case with anyone except fellow jurors. The law also does not permit jurors to allow anyone to talk to them about the case. The reason for this is that only jurors are authorized to render a verdict. only you have been found to be fair, and only you have been promised, to be fair. No one else has been so qualified. Our law does not permit you to visit a place discussed in testimony because you cannot be sure that the place is in the same condition as it was on the day in question. Also, even if it were in the same condition, once you go to the place to evaluate evidence in light of what you see there, you might be a witness, not a juror. As a witness, you may now have an erroneous view of the scene that may not be subject to correction by either party. That is not fair. Finally, our law requires that you need not read or listen to any news account of the case, and that you not attempt to research any fact, law, or person related to the case. Your decision must be based solely on the testimony and other evidence presented in this courtroom. It would not be fair for you to base your decision on some reporter's view or opinion or upon information that you acquire outside the courtroom from a source that not be challenged or cross-examined by the parties. These rules are designed to help guarantee a fair trial, and our law accordingly provides for serious consequences if the rules are not followed. I trust you understand and appreciate the importance of following these rules and in accord with your oath and promise. I know that you will do so. If you realize that you have personal knowledge about this case, you must inform the bailiff of me immediately. Judge and jurors perform different tasks. I will instruct you on the law both now and after all the evidence has been presented. You will decide the facts in this case. Then you will decide the outcome of this case by applying my instructions to those facts. Consider all of my preliminary and final instructions together. Do not single out any individual subject, point, or instruction and ignore the others. Evidence is of the greater weight. It convinces you more strongly of its truthfulness. It is evidence that convinces you that something is more probably true than not true. A greater number of witnesses testifying to a fact on one side, or a greater quantity of evidence produced on one side, does not necessarily amount to a greater weight. You alone are the judges of the evidence, including the credibility of witnesses. Credibility means believability. Credible witness is a witness whose testimony you believe. In considering the testimony of any witness, you may take into account his or her ability and opportunity to observe what he or she has testified about, the manner and conduct of the witness while testifying, any interest, bias, or prejudice the witness may have, any relationship the witness may have with other witnesses or interested parties, and the reasonableness of the witness's testimony considered in the light of all the evidence you have heard. Assume that each witness has testified truthfully. If you find conflict in the evidence, reconcile those conflicts with the case based on the assumption that each witness has testified truthfully. Do not disregard the testimony of any witness without reason and without careful consideration. If you find conflicting testimony that you cannot reconcile, decide what testimony you believe and what testimony you disbelieve. In deciding what or whom you believe, you should use your own knowledge, experience, and common sense gained from day-to-day living. During the trial, the parties may offer exhibits as evidence. I will decide whether to admit the exhibit as evidence. When I admit the exhibit as evidence, you should carefully examine it without comment while you are in the courtroom. Rules of law strictly control the offer certain exhibits that I may rule are not admissible as evidence. Do not consider or speculate about the evidence that I do not dictate or order to put in the record. Treat such evidence as though you never seen or heard. Nothing I say or do is intended to suggest what you should believe about the facts in this case or what your verdict should be. Each of you as jurors must determine the facts and the verdict. Judge the evidence from your memory of the testimony of the witnesses and the exhibits submitted as evidence. I will not provide a written transcript of the testimony. Therefore, listen carefully as the evidence is presented. You may take notes during trial. Paper will be provided. Do not become so involved in note-taking that you fail to listen carefully to the evidence and observe the witnesses as they testify. Your notes are not evidence in the case. They are only an aid to your memory of the evidence. Do not give your notes or your fellow jurors' notes any greater weight than your memory or impression of the actual evidence. You may only disclose your notes to your fellow jurors while you are all together in the jury. Do not disclose your notes to anyone else. Do not take notes outside the jury, courtroom, or the jury room. When your notes are not in your possession, no one will be allowed to read them. After your verdict is returned, your notes will be destroyed. You may have questions that you want to ask the witness. Do not address any witness directly. Do not address any questions directly to the witness. Lawyers or your fellow jurors, there are rules about the questions that may be asked, and the answers the witnesses are allowed to give. Instead, if you have a question, what we do is we pass around no case you write the question down, even if you do not have to this case is followed. First, the attorneys will have an opportunity to make opening statements. These statements are not evidence. They're only previews of what the attorneys will state. Following the opening statement, the attorneys begin presenting the evidence. They may call witnesses to testify under oath. These may also offer documents and other exhibits as evidence. The evidence is completed. The attorneys will make final and closing arguments. Final arguments are not evidence but are given to help you evaluate the evidence. The attorneys are also permitted to argue, characterize the evidence, and to attempt to persuade you to a particular verdict. You may accept or reject these arguments.
This case involves the obligations, responsibilities, the duties that property owners have, the owner of a business, to its customers, to its delivery people, anybody that is coming onto its property for its benefit. That anybody could be any of us, bailiff, court reporter, Moore, Belfry, Davis, myself, and Brian and Nicole Baldwin. The duties and the responsibilities are the same, regardless of who is on the property. And it not only deals with the responsibility, the obligations, the duties, but it also deals with being responsible for the consequences of what happens to a person when you do not live up to your duties. On December 16th of 2008, Brian and Nicole Baldwin, they owned their own delivery company. It was a small paw operation. They were making a delivery for Sieb sales in Highland, Indiana. They were making a delivery for a logistics company, and they were delivering some computer products, 6 or 7 boxes. It wasn't a big delivery. The logistics company and Sieb Sales had coordinated when the delivery would be. Window, morning, the day of December 16th. Sieb was given a 4-hour window as to when that delivery might take place. While the delivery was taking place, Nicole, who was a passenger in the truck, got out. He walked around to the front of the truck with the delivery paperwork, took a couple of the boxes in, had the people at Sieb sign the paperwork. It was snowing that day. There was snow and some patches of ice on the parking area, and Nicole will tell you, as she was walking in, she was kind of taking what I call itty-bitty baby steps across the parking area into Sieb Sales. After she got the paperwork signed, the rest of the boxes were being taken in. She went around the back of the truck, and while going to the passenger side door, she fell on an area of ice that had been covered with snow that every employee at Sieb Sales knew was a dangerous area. Everybody that day knew it was dangerous, except Nicole. She had never been to Sieb Sales before. This was their first delivery ever. Nicole fractured her ankle. She went from Sieb Sales to the hospital, where the ankle was x-rayed. She was told it was fractured, and that she should follow up with an orthopedic surgeon in South Bend, because that's where she and Brian lived. Nicole followed up with Dr. Thomas Avery. Dr. Avery looked at the x-rays that had been taken at Community Hospital, conducted an examination, and made the determination that the only way that he could try to fix this, what he will call trimalar fracture, was to go into the joint, cut into it, and put screws and plates into the joint to attempt to fix it. talk about a broken ankle, there is no ankle joint. It's just the two bones coming down from the knee, tibia, fibula, and then foot bones called metatarsals. And the bones that were fractured were right at that area called the ankle joint. The bone was to remain weight-bearing, non-weight-bearing, for a period of time and follow up with Dr. Lee. She did that. She did everything that Dr. Avery told her to do. Followed up as appointed by Dr. Avery, as scheduled by Dr. Eventually, Dr. Avery allowed her to start walking slightly on her feet. But as the recovery process went on, Nicole continued to experience pain in her ankle. Dr. Avery will tell you that the fracture that occurred in her ankle caused the formation of post-traumatic arthritis. Arthritis in the joint of Nicole Baldwin, 39-year-old. That arthritis that was forming was because of the fracture. Dr. Avery continued to treat Nicole, gave her injections, had her walk with a boot, various conservative approaches to try and deal with the treatment of pain that was happening because of this severe fracture. Finally, on September 18th of 2009, because of continued pain that Nicole was having, and now we're about 9 or 10 months out from the original fracture, Dr. Avery decided he was going to go into arthroscopically the joint and try and kind of clean it out. He'll tell you that scar tissue can form in the joint, and that scar tissue can cause pain. So he made the decision, after the injections weren't helping, after the conservative treatment wasn't helping, he was going to try a second surgery. And that was to go in and debride and irrigate, the phrase he uses, basically to clean out the joint to try and help relieve it. He did that. In the process of doing that, though, Nicole experienced an infection in the joint because of the second surgery, called a staph infection. As a result of the staph infection, a third surgery had to be performed. That was performed approximately 1 month later in October of 2009. And that surgery was going in there specifically to give Nicole heavy-duty antibiotics to try and help clean out the infection that occurred with second surgery. Nicole continued under Dr. Avery's care. Continued with injections. Continued attempts at conservative treatment. And finally, in June of 2009, about 11 months, 10 months after the other surgery, the second and third surgery, Dr. Avery performed, Nicole was still experiencing pain. She was still having difficulty with her activities of daily living, walking, all of the other activities. Dr. Avery decided, well, I'm going to go in and take the hardware out. The purpose of putting the hardware in was to keep the bones in place while they healed. Once the bones had healed, maybe it was the hardware that was causing pain. Dr. Avery did note presence, continued formation Surgery was performed in June of 2010, and that surgery was to remove the heart. Dr. Avery continued treatment Paul after the surgery. In September, specifically September 20th of 2012, Dr. Avery again saw Nicole. She has post-traumatic arthritis. She is going to be post-traumatic arthritis will. That ankle fusion was performed January 31st, 2002. Dr. Trumbull performed the ankle fusion. Dr. Avery would not perform the ankle fusion. Nicole did not have health insurance. Dr. Avery did not pay. He would not treat her. Nicole got a job at Harrison Medicine Corporation. Brian got a job where there was health insurance. Finally, when there was health insurance, we went to Dr. Trumbull at the recommendation of Dr. Trumbull, orthopedic doctor from OSMC, performed that fusion surgery. Nicole will remain under Dr. Trumbull's care for approximately 6 to 12 months following the surgery. She continues non-weight bearing. Can't put any weight on her ankle. When her ankle eventually is solid in the healing process, she will have a fused ankle with no mobility and no ability to move the ankle as to our talk about the responsibility. This is a photograph that you'll have a copy of. This building right here is a building that is owned by Roy Nagel, Roy Nagel. This building over here, and you'll have other pictures, is the building that is owned by Sieb. This parking area in between the two buildings is the area where the fall occurred. What do we know, and what will the evidence show you from all of the depositions taken? We know that this dumpster is Sieb's dumpster. We know that this car is a car from the employee of Sieb. We know that this fenced-in area that goes from one building to the other building is all Sieb's area. And we know that the delivery truck, and it's a 24-foot box truck, basically pulled up so that the front of it was almost to the dumpster. This is where Nicole got out on the passenger side, walked around to the front, and went to the door. When she came back around, and this is the area where she fell. Originally, Sieb Sales was the only defendant in this case because the delivery was being made for Sieb. Sieb knew that the delivery was coming. And Sieb, throughout the years, had always maintained, consulted, plowed the area between the two buildings. In fact, what we learned during discovery is this building over here, owned by Mr. Nagel, and Mr. Micah and Mr. Rez were tenants. They owned a little auto restoration shop. If any of their customers parked in this area, the Siebs would go crazy. They would yell at these people, telling them to keep their cars out of this area. We know they control the entire area. But when the lawsuit was filed, they then said, well, wait a minute, the truck was kind of straddling the property line, and this was actually their property where she fell. Even though the evidence is going to be Sieb controlled this entire area. Sieb knew that this was a dangerous area. In fact, in deposition testimony, Derek Sieb was asked, on page 45, lines 2 through 11, question, now before December 16th, 2008, did you know the area where the water accumulated on this downspout would freeze when the weather got cold enough? His answer, everybody in the shop knows it is a dangerous area by that time. Derek Sieb continued when I asked him, so you would agree that when you saw Nicole on the ground, you knew that she had fallen on the ice that was covered by the snow. The evidence is that this ice would form, it would thaw, refreeze, thaw, refreeze. And on December 16th of 2008, that dangerous area that day, because it was snowing, was actually covered by a layer of snow. You knew that she had fallen on the ice that was covered by the snow. Answer, yes. And the area she was this dangerous area that you told me about, correct? Correct. I asked her, having that knowledge, that would cause you to, I assume, be more careful than you otherwise would be because you knew it was a dangerous area. He said, correct. Then I asked Derek, knowing before Nicole fell that this was a dangerous area, did you ever provide her with any type of warning that it was a dangerous area for this incident? He answered no. Joseph Anopoulos, I'm just pronouncing his name, I apologize for the mistake. Anopoulos is an employee of Sieb Sales. And he was asked this question. And Derek said that that's kind of a low-lying area. The water coming down from the downspouts off the building where usually all the restoration was accumulated in that area. You were aware of it. Joe, the employee, said yes. Question. In fact, I think he called it a dangerous area because of the fact that it was low-lying and it was free. Yes? Do you agree with that? Yes. Mr. Micah, in his deposition, said it was Sieb's parking lot. Mr. Micah, Richard Micah, was the father-in-law of Jim Rez at the time of this incident. It was Sieb, Mr. Micah said, it was Sieb's parking lot because my son-in-law's business parking lot was on the west side of the big door. That is BJ Auto Restoration. Their parking lot is right there where that car is. In fact, that's Rez's car. Okay. So what your son-in-law has indicated to you, that the asphalt area between the side of the building facing the Sieb building, that was all Sieb's parking. That's what he understood. Because sometimes he would park, the customer would park the car over there, and the Sieb brothers would chase them out of there. Roy Nick, the owner of this building, was asked, did you ever engage in snow removal at the premises while Mr. Micah and Mr. Rez were said no? Because Sieb Services was empty. Because the property, again, we're going to revisit this exhibit, as you'll notice the fence is all the way up to that line. Sieb Service would do all of the plowing in that area. How long has Sieb Service been doing the plowing in that area? Since the time that I took over the building. Was there ever a time that you had your tenants clear or do snow removal in that area? The answer was no. And the last testimony from Roy Nick. Is it your testimony? Correct me if I misunderstood your testimony. From your perspective, it doesn't make any difference where yellow lines are placed in the asphalt between the LakeCo leasing building and the Sieb building. Because throughout the years, from the time you owned, LakeCo leasing owned the building. The Siebs were the entity that controlled the asphalt area in between the buildings. The answer, they still do. Once the complaint was filed, Sieb Sales then named Roy Nagel, LakeCo Leasing, Jim Rez, BJ Auto Restoration, and Richard Michael as people, they call it a non-party defense, as people that may be responsible but aren't a party to the lawsuit. That then forced the plaintiff to amend their complaint to bring all of them in. And what I'm saying to you is, they were brought in because Sieb Sales said they were responsible. The evidence is going to be Jim Rez and Richard Micah did not control the area in between these two buildings. They didn't do anything wrong. The evidence is going to show to you that Roy Nagel, LakeCo Leasing, the owner of that building, this is his downspout, right here, and this is the downspout that where the water comes. But Mr. Nagel's going to say that downspout wasn't like that. It actually went around the corner and took the water in a different direction. But the evidence is going to demonstrate to you Roy Nagel and LakeCo Leasing were not the cause of this fault. The dangerous condition, known by Sieb, never communicated to the Baldwins, was what caused the fault. Sieb Sales was responsible and should be held accountable for the damages that Nicole and Brian have gone through, and Nicole will go through. All we're asking is a just, fair award. When you
name other defendants, why did the plaintiff sue them? Because you haven't heard any of them. Openings are great, because when an attorney says to you, represents you in opening, hold them to it. Hold all of us to it. Does the evidence actually say what you just heard? I want you to hold me to what I'm telling you today. I do agree with the plaintiff, though. This case is about the consequences for your choice. On the date of the fall, it was an icy, snowy, wintry day. The plaintiff, Mr. Baldwin, described it as a horrible day that was treacherous. They make a delivery to Sieb Sales, and unfortunately, Ms. Baldwin slips and falls, breaks her ankle. The evidence is going to show you that Ms. Baldwin fell, and Ms. Baldwin broke her ankle because of the plaintiff's refusal to follow instructions in the delivery process. And I'm going to show you the lay of the land. I was not able to see that delivery actually over there. So if I repeat, I apologize. The evidence will show you this is Sieb's building. They own up to about here. This is LakeCo building, and Mr. Nagel, that's his company. He leases to Micah and Rez, who are the tenants right here. There's a downspout there. Water's coming out of it. Right there. Plaintiffs come with their delivery truck. It's not a pickup, but it's certainly not the size of this cell. They pull up and they park here to make a delivery here. When they show up, Sieb says, come on over to our delivery pool. Make your delivery, we'll get our forklift and take care of it. Plaintiffs say, no. Small delivery will be in and out, treacherous conditions. Here, Sieb says, well, let me take the forklift from here. I'll drive it around here. I'll pick it up and bring it back. Take treacherous every day. All of it in and out. Now, delivery men proceed to make the night. And the way walking past all the shows up the passengers by this downside of the LakeCo not the sea. The evidence is going to show you. Evidence is going to show you that the truck was straddling the property because of the decision of Baldwin to not follow the offers of Sieb for delivery. Evidence is going to show you that Ms. Baldwin was forced to walk on someone else's property because of their decision not to follow the delivery. The evidence is going to show you they were never invited onto that property. They were never invited by Mr. Michael. And they certainly were not instructed by the Sieb. Now, because of the allegation made, and because there is someone else's land at stake, someone else's property, that's part of it. No, people, they were sued. They were sued by the plaintiff. That's why they're here. This is not just following. There is a lease. And you're going to see that lease in that we're talking about. The lease says, Micah and Rez are supposed to be snow and ice from this area. The area where it's called the lease says the land is supposed to continue this downside area. Now these are issues that are necessary to fix because we've been sued by the plaintiff. The accident occurred at that area of the lot. Not that's why this part is hard. That's why they have to be dismissed. That's why we're all. So maybe there wasn't this. Maybe the employer. I don't know. But the evidence will tell you that, unfortunately, because they refuse to take instruction. And at the end of it, I keep the fight.
We like to have one. It's the same one. As I've indicated earlier, my name is Brandon Stokes, and I represent the kind of lawyer. Well, first of all, let me say thank you for taking time away from your lives. I understand what it's like to be in your shoes, been there myself, and I understand that you realize, or we realize, many other things like because we're all busy, but being a part of our society, participating in a number of years. So what you do here is a vital part of what you practice. As you've been told, this matter involves slip and falling in the third of This is Nicole Baldwin delivering computers to defendant sales during the snow event. She was there with her husband, Brian Baldwin, the duo, Baldwin Enterprise, and other. Now, how right wait, did you do this? As you can see, we're the name. That's a good question. We're just the name. You've already heard the plaintiff say you're not the plaintiff. The plaintiff doesn't think it's me. And we did. All we did. Clear defendant saying our downfall caused water cooling event 3. They never told LakeCo, Nagel, any problems with downspout to the incident. As a matter of fact, the hearing of the downspout here only came about much later after. So that the history is not important. In fact, parking lot area sloped down, mounted with something. Therefore, the water could be cooled. The evidence will show that this is Baldwin's fault, either for Sieb's problem, or that Sieb's sale appears to have been non-responsible for the snow and ice from the entire party. Taking the look at the fault is important. Sieb's sales appeared to be service of their service. The evidence is important. Solid and moved the party. One Nagel and LakeCo were not responsible for selling or moving any portion of the party. As I said, our only goal is to Baldwin got her liberties. She wasn't there for any purpose related to Roy Nagel or LakeCo. Sales. There will be don't listen. But Roy Nagel and LakeCo will charge on this because we have to. your name?
Nicole Baldwin,
Where do you live, Nicole?
South End,
How old are you?
39,
Courtroom, you have to do. Your date of birth.
11/28.
Nicole, are you married?
Yes.
Where's your husband?
Right.
How long has the two of you been married?
10 years?
Date? That's the harder question.
5/17/03.
Oh, usually, the husband does it. Nicole, are you currently employed?
Yes.
And where's that at?
10 years in that
What do you do at 10 years in medical school?
kindergarten to 8.
No, very good thing for kindergarten.
Mostly for young.
How long have you had that job? So the first school year that you were in contact with was 2012, 2013. Before that, were you employed? Where did you work? What did you do there? As a delivery driver, what did you do?
I deliver medications.
Would that be in the South End area or what would you do?
It would be from South End up to and including South
How far west?
I guess
So this is working on South. Now, some question I do and your husband. took place between the dispatcher and the customer. Was that a time period of delivery from your perspective that was agreed upon with the dispatcher?
Yes.
Once that agreement was reached with the dispatcher and the company, that the delivery was being made to, how would you and Huntington know where to go and what happened?
Our days would begin with Farmington office handing invoices to the patient. So at that point, we would match the delivered note as well as the patient. That would practice of ours in the direction of how to take. Then we would organize those, use whatever mapping tools would help us in the delivery. Set them up with guess the best routing. On that.
So you and Brian would establish the routing, which we're going to go through first, second, third, fourth, fifth. But people logistics engage with the delivery. You and Brian were not employed. You and Brian chose not to take the delivery. Now, December of 2008, December 16th time period, that like before Christmas, that was easier time of the year. Sorry? That multiple hour day time period, something that you and Brian would work routinely in the Thanksgiving for December 16th, 2008. Do you have a GPS and you would put address to the computer so that you know where you
Then we would produce program.
So based upon people logistics giving you the delivery sale, please know that you're comfortable. You remember March 16th, 2008, whether there's delivery, seat sales, first delivery, second delivery, where it was.
Yes, I believe it was just about
Remember, generally, the general area is going to be where you route your things.
prior to that period.
So your earlier deliveries have all been in the late county area and further. Out there in front of you is the book. You open that to the book to the left. Exhibit 11. Is that a book? Is that a photograph of the type of truck that you are hiding in When you got to Sieb sale, were you driving or were you a passenger? Do you remember when you got to Sieb sale where Brian pulled the truck to the parking lot? Where were you then? There's a dumpster here that's full of phone. You remember where the truck was early that night?
I don't
There's a red car there with the truck that gone all the way to the parking lot inside that.
It does look like wood, but it's not clear.
When you got out of the truck, once you get there, you're in the passenger. What is your job or your responsibility?
I would report the time to the arrival.
Okay? And where would you report that?
Yeah, Baldwin.
And I just say where those reporting of the arrival time is that for your benefit or for Okay. Then after you reported the arrival, is that how you remember it was you? After you reported the arrival time, what did you do?
I would gather the paperwork that we need to provide us with the cargo during what it was the
Do you remember specifically what was the
There weren't very many things.
When you first arrived, before you got out of your truck and started to go into the building, did anybody see you going over here where you're making? Did anyone in that building come out and someone from
I did not hear the conversation. But if he was at the door, something about
the conversation with the person that leaves the truck.
Correct.
By the time that conversation takes place, they move on to the truck.
I was like,
When you got out of the truck, you go around front of the truck or the back. And where were you going? What was your intention?
Did you in fact meet Brian? Where did you meet him? Then what happened next?
At any point in time while the person from Sieb was talking, did you ever hear anyone from Sieb say to you or to Brian, don't park the truck where you park? Did you ever hear anybody from Sieb say to you or to Brian, you need to pull the truck over to the bed? How long would the unloading of this delivery? So we're talking about a delivery that wasn't going to require much time. Was the type of load you guys were delivering, was that the type of load that was even compatible for the forklift to take into after the parking area was spelled out. Like a 241. What type of clothing? When you went inside, don't worry what happened inside. You formulated an expression of mind there about this. After you got that inside, you keep a copy of that inside. Then what happened? Yes. Is there only one person who you're walking back out after you got to take one side? Tell the jury the route you took. Why did you go that way as opposed to the other side?
I would always be forward.
Was there any help or assistance that was needed in those boxes? Tell the jury what happened when you were walking on back and stuff. About all the employees at Sieb knew that the area where you were was a dangerous area. Was that fact ever communicated? Was that fact ever communicated? Tell the jury what happened. you ever treated them? How is it that you became aware that before December of 2008, African Congress, did you have any type of routine blood work done periodically or any point in time up until December of 2006, any time? Individuals that help you properly. When you say they help you during the process that you're trying to get help. So the step, this is from the driver's side, the passenger side, and the driver's side. So you had to step up onto the flat area to even try and get some type of footing. Which ankle was it? How is it to attend to that? Now, you say that this delivery was made about 2 o'clock. Did you and Ryan already had lunch that day? You mentioned that when you got back into the truck, you were going to send a message to people logistics that the delivery had been made, correct? Was that device that was inside the cab of the truck?
Yes. It is our personal phone.
And you always keep it inside the cab of the truck?
Sometimes it's whatever the case. It wasn't attached.
At the time you fell, you did not start sending a message.
Correct. Correct. I don't believe I had the phone out at that time.
Eventually, did somebody send a message?
I did not. I don't have any sure Brian probably knows that.
How was your ankle feeling? Put any weight on your ankle? From the sales, where did you go? And generally, health is very well.
The wheelchair me from the waiting area. We put on the table.
got back to South Bend, then follow up with the Dr. Thomas. What's your understanding were you hospitalized during that surgery? After that surgery was performed, you were not allowed to enter. On December 16th of 2008, what did you do? To have an actual work doctor, record indicates that you saw you on December 2nd, about 6 days later. Help the jury understand why there was a 6 day gap. That was what he told me. You remember where it is? From there, you're going to go to tell the jury then how the follow-up care and treatment with Dr. Baker went after that first surgery. During that period of time that you were not waiting, ordered by Dr. Baker, were you allowed to besides helping the husband with delivery, how long was it you were not able to do anything whatsoever for your
I don't recall exactly.
what medication would you want? What effect did those medications have? Now this 9 days off from Christmas, you remember what you did at Christmas? You and Brian originally. Dr. Avery allowed you to start some commercial weight training. Started partial weight training was doing that with kind of assisted life. During the period of time that you were on weight bearing, you could use a device in order to lift the load. They didn't have those down. So how you get around so all the time continuing with occupation therapy, which is generally have all the medicine. Generally type of care.
Checking. You did actually like interpret both of them at that point.
Were you having pain as the recovery from the surgery?
Yes.
Describe if you would to the surgery that pain that you were experiencing.
Here. Here. Negative. Just make the very nice person. Grabbing.
Once you started the weight bearing, partially, so once you started the partial weight bearing, well, the jury would put some of the things that Dr. Avery did all the way up until the second surgery. I talked to him.
I know we did.
Remember approximately Well, once Dr. Avery allowed you to do commercial weight bearing, if you have any restrictions, what are some activities that you are doing with your dog? Or you're going to do with sports type? What are they doing?
men's basketball for 5 years, I believe. Volleyball, I think, one season. And softball.
Did you still play in softball leagues up until the winter months of 2008?
I did not.
When did you stop playing organized?
When we moved to South Bend, it would have been in 2004.
So you hadn't played softball for about 4 years.
Correct.
Why did you and Brian move to South Bend?
We had the opportunity to take the truck that we had and own our own business here versus working for somewhere else in Ohio.
Eventually, in September of 2009, did Dr. Acree recommend
Didn't go well.
explain to the jury why not?
I refused somehow infection on that surgery within it's just too hopeful in the front of the foot.
And Dr. Acree ended up to do a third surgery within 30 days.
Yes.
What's your understanding as to the third surgery?
We were looking into severe infection. Look for any other
Did the second surgery Dr. the fourth surgery on June of 2010. You remember that? From October 5th, 2009, we had the third surgery because of the infection. From then until June 2nd of 2010, tell the jury how you did during that period. Did you continue to treat with Dr. Acree? Did Dr. Acree attempt to give you more injections?
I believe so. I think we tried one more.
Did Dr. Acree suggest any other type of conservative approaches to help you with the pain that you experienced?
I believe at that point we tried bracing. I don't remember if it was like an air cast or what exactly it was, but that didn't help.
Yes.
Ladies and gentlemen, they take.